Good afternoon. Today is August 14, 2025. It is approximately, well, shortly after 1 p.m. This is the matter of file Z0137-25, an application for a non-conforming use verification with an associated proposed alteration. The applicant's proposing verification of an existing home built within the front setback area within an rural residential farm forest 5 acre zoning district. Uh, the applicant's requesting approval for roof replacement and structural improvements as an alteration. This application was first processed by the county, type 2 process by Maya Ganzer, Planner 1. I see that Ms. Ganzer is present and approved. The approval was then appealed by Lori Ryland, and I see that the appellant Lori Ryland is also present. Present is the applicant, Ms. Jennifer Kapnick, the co-owner of the property, Terry Eidsmo. They're represented by attorney Matt Martin. I believe I've named and we have another staff member, Lindsay Nesbitt, also present, and our moderator, Darcy Renner. My name is Carl Cox. I'm a private attorney appointed by the Clackamas County Board of Commissioners as Land Use Hearings Officer with authority to conduct this hearing and make a determination in this matter. I'll state several important things for the record. This is a quasi-judicial land use hearing, which means two important things for those participating in this hearing. First, all of the criteria that can be used in reaching a decision have been identified in the staff report. Testimony, arguments, and evidence must be directed towards the criteria identified in the staff report or other relevant criteria found in the comprehensive plan or other land use regulation that the person believes applies to the decision. Accordingly, please direct your testimony to a relevant approval criterion. Second, failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties an opportunity to respond to the issue may preclude appeal to the Oregon Land Use Board of Appeals on that issue. Failure of the applicant to raise constitutional or other issues relating to proposed conditions of approval with sufficient specificity to allow the local government or its designee to respond to the issue precludes an action for damages in circuit court. Once final, this decision may be appealed to the Oregon Land Use Board of Appeals. I will state for the record that I've not received any ex parte contact in this matter. No one contacted me outside of these proceedings to try to persuade me concerning a fact or issue which is present in this hearing. I have considered issues of bias and conflict of interest and have determined that I do not have any bias or conflict of interest in this matter. The county is making a record of this hearing. That record is available through the county. At this time, I'm going to ask that the county provide an explanation concerning participation in this hearing via the Zoom platform. Please proceed.
This public hearing will be conducted virtually using the Zoom platform. Panelists for today's hearing, which include the hearings officer, county staff, and the applicant, both have audio and video capability. Audience members who have joined the meeting will have their mics muted unless they wish to testify, in which case they will be called upon to do so by the county staff moderator. Audience members' video will not be turned on at any time. Today's hearing is being recorded as required by law. The county will make every effort to post the recording on the county website later today. There is a designated time during the hearing when it will be open for testimony. The hearings officer will make it clear when this is. If you want to provide testimony, you will utilize the raise hand features. If you're attending on a PC or iPad, you have a raise hand button on the bottom of the Zoom bar. When the moderator switches you over to provide testimony, your screen will look different for a little while. Primarily, you will see all the participants' cameras, not just the one who is speaking. Staff will call upon you when it is time for you to provide testimony. Be sure to provide your name and mailing address when you begin. Once you have provided your testimony, your mic will be muted and your screen will be returned to normal. If the record is left open at the end of the hearing and you wish to submit additional written testimony, email written testimony to myself. I will provide my email at the end of my presentation, or mail it to Clackamas County Planning and Zoning Division at 150 Beaver Creek Road, Oregon City, Oregon 97045. And I also have that address at the end of the presentation. The staff contact email address is also available on the webpage where you found the Zoom link for today's hearing. Testimony must be received by 4 p.m. on the day the record closes. People who testify and provide their mailing address will receive a copy of the hearing officer's written decision. If you do not wish to testify but would like to receive the decision, you must provide your email or standard mailing address. You can email it to the staff contact for the application or enter it into the Zoom chat function during the hearing.
Thank you. This hearing involves verification of an application for verification of non-conforming use with an associated proposed alteration. The burden of proof here is on the applicant to prove a couple of things here. First, that the residential structure on her property was built prior to zoning, and secondly, that for the 20-year period prior to the date of her application for non-conforming use, that the non-conforming use was not interrupted for more than a 24-month consecutive period. So those are the relevant issues that we're here to discuss today. As I stated, the applicant has the burden of proof. The order of proceedings will be that I will start the hearing by asking the county to present a staff report concerning its review of the original application and, well, the entire application, and followed by an opportunity for the applicant to supplement, as the applicant chooses or does not choose, the presentation by the county, followed by an opportunity by the appellant to submit testimony and evidence or reference materials that have been submitted to support her appeal of the county's approval. I will provide an opportunity for members of the public to also provide public comment concerning this application, actually, because I'm deciding the matter de novo, meaning I'll be taking the place of the decision maker here. And I will provide an opportunity for rebuttal by the applicant. Are there any questions before I begin? Okay. What I'm going to ask is that as I call upon each of you provide testimony or advocacy, that you state your name and indicate whether you've provided your address. And if you haven't, state your address also for the record. Ms. Ganser.
All righty, 1 second. One second. Let me do a.
Okay.
Are
And I
you
see
seeing
that
the?
you have a PowerPoint presentation. Do you intend to submit this as an exhibit?
Yes, and I will just share it like this.
I have 80 exhibits
Yes.
currently.
Yeah, it
So
is
this
not
would be,
currently one of the exhibits, but I will upload it as one after the hearing.
okay, at least by 4 p.m. I'll discuss the period for closing the record prior to the end of this hearing.
Okay. So 1 second. Sorry, I don't use PowerPoint often, so I'm not sure how to make it into the big screen. 1 second. Yeah.
Down at the bottom where it says display settings and right before the volume, there's like it looks like a screen on a, like if you go to the right a little, go to the right one more, and to the last one, click that. That'll make it one.
Okay, are people seeing the whole screen or are they also seeing the notes?
We're seeing the screen and then the next slide.
Okay, sorry, I'm trying to figure out a way to
I wonder,
just show the whole screen.
right, what does that do? Oh, that's just see all slides. More slide options. Hide, oh, maybe try. We can just roll with this. I think that's what a lot of planners do. If you just want to hit your down arrow. Yeah.
Yeah.
Okay,
Okay.
sorry.
No worries. Alrighty, so I'll briefly be going over the proposal, summarizing my staff decision, while also addressing the concerns raised by the appellant related to the relevant zoning and development ordinance criteria. So a brief aerial picture of the property. I just want to note that while the property does contain the TBR zoning district, the subject structure is entirely outside of the TBR zoning district, and hence section 406 is not discussed in the applicable zoning in the presentation or in the staff decision because it's not applicable criteria. You can see the zoning boundary right here and the subject structure here, and it lies entirely within the RRFF5 zoning district. Here is a site plan. This was provided by the applicant. It is in the staff report and also in the applicant's exhibit, exhibit 2. So this is related to a non-conforming use alteration and verification application. The applicant applied for a NCU verification for the setbacks of a dwelling that was built in 1930. The structure does not currently comply with the RRFF5 30-foot front setback stated in Table 316-2 of the ZDO. The subject parcel became subject to zoning regulations on December 14th, 1967. Sorry, that is not so. Where it was zoned RA1. The property zone was changed to its current zoning designation RRFF5 by zone change 43-79, which was effective on June 19th, 1980. In 1980, the RRFF5 zoning district had a 30-foot front setback requirement. So essentially the property has been subject to this 30-foot front setback requirement since 1965 or 1967. Just as a contextual note, the dwelling does encroach into the right-of-way of Cedar Creek Lane, not the as-driven location. County engineering has issued a revocable encroachment permit. This information is contextual and it's not within the scope of the NCU. This is an engineering process, but it has come up in a lot of public comments, so I wanted to address it. Staff found that the use existed prior to setback restrictions and that with conditions of approval to mitigate impacts, the roof replacement and structural improvements will not create greater adverse impacts. And so staff approved the decision on July 14th, and it was appealed on July 21st. To go over some of the approval criteria, Section 202 of the ZDO defines a non-conforming use, which is any use of a building, structure, or land allowed by right when established or that obtained a required land use approval when established, but due to a change in zone or zoning regulations is now prohibited in the zone. The use is permitted in Section 316, which regulates the RRFF5 zoning district, states that detached single-family dwellings are an allowed primary use in the RRFF5 zoning district. So hence the use of the structure as a dwelling is not a non-conforming use. It's an allowed primary use, and it's not the subject of this decision. What is non-conforming about this property is it is non-conforming with the dimensional standards stated in section 316.04, specifically table 316-2, which outlines that the RRF5 zone has a 30-foot front setback standard. The property has 2 fronts, also defined as section 202, the south and east property line. The structure doesn't comply with these 30-foot front step back standards and hence would require a non-conforming use verification and alteration. Related to the location of the structure, not its use as a residential dwelling. There was a lot of public comment related to this application, so I do want to briefly go over the scope of a non-conforming use. This one specifically, it is subject to ZDO sections 202, 316, which I just went over, 1206, which regulates non-conforming uses, and 1307, which is procedures. The scope of the NCU does not include some issues raised by the appellant, including transportation, such as legal access and parking, septic capabilities and water access, occupancy of the dwelling or vacancy, dwelling habitability, FEMA and RISCA regulations, and alleged past illegal use of the property. These are all subject to different review processes. This structure is still subject to the same building code, fire code standards, land use, FEMA, engineering, and septic standards that any other dwelling would be, and will have to go through relevant review processes related to those, but those are just not included within the NCU review process. So now I'll go over the approval criteria for section 1206, which is the bulk of the decision. 1206-04 is related to the discontinuation of use. As stated previously, a non-conforming use cannot be discontinued for a period exceeding 24 months or 2 years, or else the non-conforming use status is lost. Staff reviewed aerial photographs of the built structure. There's a 2004 one included in the staff decision, and found that it had not been discontinued for a period exceeding 24 consecutive months. The applicant provided a tax jacket from 1996, which states the home was built in 1930 and its size. Assessment data from 1993 until now demonstrates that there was a consistent residential property tax rate on the property. The residential use of the property, again, is not subject to verification, but the property tax data information does provide information regarding the consistent presence of the subject structure on the property. And based on this and the fact that the NCU is related to a built structure, it's unlikely that it really could have been discontinued and removed from the front setback and then put back, for a period exceeding 24 months. And so staff found that section 1206-04 had been met. The appellant submitted comment disputing this staff finding, stating that the use had been discontinued because there was a lack of occupancy in the dwelling, or occupants hadn't been legally living in the dwelling. This was prior to the current property owner purchasing said property. But as stated before, occupancy is not a standard for discontinuation of a built structure. The structure was still physically there, and the residential use is allowed outright. Additionally, occupancy and someone not paying their rent is not a factor when it comes to a land use planning decision related to discontinuation of a residential dwelling.
On residential
Staff.
property.
Mhm.
You mean on residential property?
Yes, yeah.
Correct.
Hence, staff was not able to, considered the complaints, ultimately was able to determine that in the RFF5 zone, since the dwelling is allowed outright, that these issues raised were not applicable to the standards in section 1206 of the ZDO. The use of the residential dwelling doesn't need to be verified because it's not non-conforming. What is non-conforming is the setbacks. The applicant, related to verification, chose to go with standard A, which has the 20-year period, which you can read up on the screen now. And then I'll go over staff findings related to that. So as I stated before, the property became subject to restrictive zoning on December 14th, 1967. Clackamas County appraisal records from 1996 verify the existence of the dwelling built in 1930, and established that the use existed prior to zoning regulations. Property tax data shows consistent residential property taxes from 1993 on. Staff reviewed aerial photographs showing the dwelling in 2004 and various dates after that. There was a survey recorded showing the encroachment distance, so verifying that the dwelling encroached into that front setback standard area. The survey is in the record, and it shows the distance encroached into the front setback area and the right of way, and this was recorded in 1993. And staff found that the structure's non-conforming setbacks were just established prior to zoning in 1930, and the applicant provided proof of continuous non-conforming use, that being the location of the structure in the front setback standard exceeding the 20-year requirement. The appellant has stated that the home was expanded without permits. However, there was no evidence provided of this occurring, so staff wasn't able to consider it. Additionally, the application only relates to the front setback standard. So unless that expansion occurred in the front setback standard, it wouldn't necessarily have a bearing on the non-conforming use. And the applicant provided evidence exceeding that 20 years that indicated to the contrary. The appellant provided a 1937 deed, which is Exhibit 57. Which described the subject parcel for 0220 Southeast Cedar Creek Lane. And it doesn't mention a dwelling, but that's not typically done on property deeds. Property deeds typically just list the boundaries of the land for a subject property, not what structures are on it. So this is not really evidence disproving that the home could have been there in 1930 and was built in 1930. So staff found that ultimately the applicant had provided enough evidence to prove the existence, continuity, nature, and extent of the non-conforming use for a period exceeding 20 years. And so found 120605 had been met. 120607 relates to alterations. As stated previously, the alteration relates to a roof replacement and structural improvements needed for the property. The roof replacement, based on the applicant's submitted site plan and drawings, does not expand further into the setback area, so causing no greater impact on the non-conforming setback. The encroachment distance is to be verified by a record of survey per conditions of approval to verify that distance, because we were working off of a 1993 survey. The appellant raised concerns regarding structural integrity of the building. And staff would just like to note that if this is approved, the structural concerns are addressed because this is for structural improvements. And that's also not a criteria of section 1206. You know, the other concerns that they had related to fire safety, septic access, and construction are either handled through different review processes, largely through the building permit process. So those aren't applicable to the applicant meeting 120607, and none of it really raised any evidence that allowing the applicant to replace the roof and do structural improvements would create greater adverse impacts than the existing home already has. This is just the finding related to the condition of approval. Additionally, just as a note, that building, engineering, and septic permits were not conditioned as they're required outright. So when the applicant goes through the building permit process, they will be going through the review process with county building, engineering, and septic. The appellant had some concerns related to the procedures of the land use decision and section 1307 that I want to address. The appellant stated that the county did not comply with 1307 on their appeal submittal, which is Exhibit 28. As the hearings officer stated earlier, non-conforming uses are a type 2 land use procedure. The appellant wanted a hearing prior to the decision being issued, but as this is not a type 3 decision, it's handled administratively, and a hearing is only held unless appealed. The appellant was sent the notice of application and notice of decision by mail as required by the zoning and development ordinance. The appellant raised issue that the county did not include the CPO recommendations in the application packet. as a violation of section 1307. However, notice for the application was sent out prior to the CPO comments. Notice was sent out in May. That was how the CPO was made aware of the application. The CPO, a board member, provided an email to myself in June. The minutes were not submitted to me in that email, and they were later submitted by the appellant on August 11th, which is Exhibit 71. And staff, as they stated in my decision, we did review all public comment, including the CPO comments and the appellant comments, and determined that none indicated that the application didn't meet the applicable criteria in ZDO section 1206. However, their concerns were addressed in the relevant findings. And so ultimately, based on the submitted information by the applicant and the appellant and other members of the public, staff stands with their initial decision of an approval with conditions and recommends that this non-conforming use verification and alteration be approved. That concludes my presentation. I have my email address up on this slide, along with the file number. If you would like to provide me with written testimony, you can email me, or you can mail it to the address also on this slide. And I'll leave it up for a little bit so people have time to write that down.
And please name this as an exhibit and
Yeah.
submit it by 4 p.m. today.
Yes, I will. Thank you.
I'd like to provide the applicant an opportunity to provide supplementary evidence and advocacy, legal argument in support of the application.
Thank you very much. My name is Matt Martin, and I'm with VF Law. My bar number is 126314, and I represent the applicant along with my colleague Andrew Stamp, who is not here today. And I have a few brief comments, and then I believe that the co-owner, Mr. Eismo, has a short statement to make as well, and then we're available for questions. But given the conclusions and findings offered by staff, I don't think I have much to add to that, and so I don't want to waste your time by duplicating that effort. I mean, I think the objection by appellant is now part of a broader set of cases. There's been, as has been referenced in the appellant's materials, a quiet title action filed in the Clackamas County Circuit Court. That is, I mean, first time I had seen it, there was what appeared to be a motion for a preliminary injunction to prevent this hearing from going forward. That was denied. So I think there's a tendency to blend the issues from one proceeding with another proceeding. And as staff pointed out, the issues for this non-conforming use verification and non-conforming use alteration are very narrow. And most of the appellant's exhibits aren't material, they aren't relevant, and so just largely not going to address them. I think the evidence that staff discussed and referenced establishes that the residential use of the property began in 1930, and that establishes step one of the non-conforming use verification standard in section 1206.05A, so because the use was lawfully established residential use, then the applicant is only charged with a 20-year look-back period. So from that, then it's apparent from the tax records and the aerial images that go back to the early to mid 1990s that the property in its current configuration has existed. And I mean, I think non-conforming use verifications will always necessarily require the decision maker to extrapolate from discrete points, because you're rarely going to have someone who lived on the property for the full 20-year period say, yes, it was exactly the same. And that's what we have here. You can look at discrete points and know that it is extremely improbable that someone deconstructed a deck and then left it that way for more than 2 years and then rebuilt it. That's not the standard that is required, and that's not what we have here. It's just, that's not how people run their property. And so the evidence in the record meets the substantial evidence standard based on the tax records and the aerial images. You have the comments from, there was a question about the tax, a drawing in the assessor's map, which I believe was the architect for my client ably responded to in Exhibit 2D. There's a letter addressing that and explaining why the plan drawing in the assessor is, I believe, off by 90 degrees. And that's really the only relevant, I would say, argument against continuity is that somehow this deck on this square piece of property was rotated 90 degrees. So otherwise, we have a property that it sounds like is not in great shape, and two property owners who are pouring, their heart and soul and money into making this a livable property. They're doing so within the current dimensional standards. And I suppose I should say that in speaking of the proper focus for this, the non-conforming.
Wait, just a minute. I would like you to clarify. You said they're doing it within the current dimensional standards. You didn't mean that, did you? You meant they're doing it within the current, not the standards, but the current existing.
Sorry, you're right. Yes, you're right. Not the applicable standards, but the dimensions of the property.
Because that's what we're here to talk about partly, is that this doesn't fit within the standards. Right.
Yes.
Okay.
Yes, we wouldn't need this if it did. They're staying within the existing building footprint. And the building footprint that has existed within the setback and violated the setback for the past 20 years, or the 20 years preceding the filing of the application. And then with the alteration, again, I don't want to belabor what staff's presentation, but the type of structural and health safety issues that are raised by appellant's objections are issues that should be addressed in the permitting process. That's not relevant to the issues here. That the standards under 1206.07 sub B, that it will have no greater adverse impact on the neighborhood by allowing this house to be used as a residence. There, you have one residence that is continuing, and so the impact on the neighborhood is not going to increase by allowing them to build a roof over their heads that's structurally sound, with the caveat that structural soundness isn't actually relevant to this proceeding. So let's see, I had a couple. I think we would like to request an open record period, because to sift through all of the exhibits and confirm that have a fulsome review.
I noted you requested it, and I will make a statement before closing the record, and I won't close the record today.
Okay.
There will be an open record period, and I'll make a statement about that before we close this hearing today.
Okay.
You said that you had the co-owner of the property wanted to make a statement.
Yep. Yes. I unless you have any questions for me, I will turn it over to Mr. Eidsmoe.
Please state your name and address, and you're muted too, sir.
Hi, my name is Terry Eidsmoe. My address is 6352 North Columbia Avenue in Portland, Oregon, 97216.
It's not.
Can you hear me?
It's North Commercial Avenue.
Oh, I said Columbia. I'm so sorry.
Let's get,
I've-
please restate your correct
Yes.
address.
6352 North Commercial Avenue, Portland, Oregon, 97217.
Thank you, sir.
Thank you. Jen, thank you for catching that. I guess the only things that I have to add are just really context. I think Maya's presentation and what Matt had to say covers mostly everything that we would be able to provide. This property has a water right to a well that is located on Lori Ryland's property. She turned the water off to that property and has done everything in her power to try and diminish the value of that property. At one point, she mentioned to us that we should offer $100,000 to, or that we should offer $95,000 on the property when we were going to make an offer to buy. We thought that was amazing that she had some sort of insight to this, and then we decided to offer $100,000 on the property. And lo and behold, she had also offered on the property.
I'd like to keep this relevant to the issues.
Yep.
that are
And so
here.
then I'll
let's-
just stop with that. That was just the context that I wanted to add. Thanks for your time, and I appreciate the effort.
Thank you, sir. I'd like to provide the same opportunity for the appellant, Ms. Lori Ryland. Do you prefer Ms.?
Yeah, that's great.
Okay. To provide evidence and testimony, argument in support of the appeal. And I'm going to ask that you direct your arguments and testimony and the exhibits you reference to the issues that we're discussing here today. The relevant approval criteria, but I will, as I stated to Mr. Martin, there will be an open record period, and I invite you, if there are other items that you want me to look at and determine whether they're relevant, you can submit that at that time. Organize a written statement can sometimes be helpful. Please proceed.
Okay, well, first of all, we had a meeting, I was invited to attend the CPO's meeting, with the fire department was there. And they looked at the whole planning decision that was 18 pages. And they determined, they voted, and they determined that it was an extreme fire hazard and risk with the way that our road is now. It's very dense. It's a single lane road, and it's where the state of Oregon is under extreme fire risk. So they advised Maya Gesner in a letter that they would not proceed forward with any development without having the fire department be able to get involved and do a survey and try to look at the whole situation. So that's my first concern.
Just to clarify, there wasn't ever anything to the record submitted by the relevant fire department. I would never received a letter from the fire department, so I'd just like to state that.
Well, in the letter that
Well, I'm familiar with the process, and I believe that the fire department will have another opportunity before any development permits are issued to also comment on that as well.
In the exhibits, which I have submitted 23 pages and 55 exhibits, he had a letter that he wrote to Maya. And in the letter, he made that recommendation and told her all the reasons why they voted against it.
Okay.
And that's one of my concerns is that. The second thing is that under DZO 1206, it's a very, very narrow scope. And when you apply for a permit under 1206, you don't have to have anything looked at. It's just looking at its alteration and non-conforming use. And so the first thing, I apologize that I didn't get it to you sooner. I didn't realize it was going to be 364 pages. That's like a daily diary.
I read it.
You did?
I did.
Oh,
Yes.
I'm impressed. And the house was extensively researched, which I was not aware that they did the kind of work that they did, but they had two lawyers involved with a law firm that extensively researched it with the county. And in the court document, it states that the house was trashed. They were dealing with squatters, with people that were not lawfully there, and that they were trying to evict, which eventually they did evict. And I dealt with this for 3 years next to my property. Most of the property owners, it's Cedar Creek Lane is a single, very narrow road with 12 houses on it. And on the creek side, the lots sort of go down to the creek
Yes.
a little bit. This house, 40220, it slopes really drastically down, and that's, the house sits on a slope. But the other houses sort of slope too. I own lot 10 as well, and it slopes. And so when you're in your house, you can't really see what's going on with the rest of the neighborhood. It's really hard. But in my property on 40315, which is adjacent to 40220, I sit above it. And so unfortunately, if there's a lot of problems and a lot of stuff going on, it's right in my face. So unfortunately, the 364 pages was my life for 3 years. And the house is the only house on that creek side that it is over 1,400 square feet. I think the biggest house is my house, lot 10, which is probably 13 something square feet. And so that's been one of my problems with that house. And yes, I did make an offer to buy it. I was gonna just take the whole thing down and be done with it and have it out of my life. I made an offer to buy it at the exact, pretty close the same day as Jennifer did. And she was able to get it because she had, I required a clean title and she didn't, but it doesn't matter. I know that she wants to have it be her house and live there and have it be real pretty and nice. My problem is under Z0137-25, you don't have to have, it's very, very narrow scope. And it's an alteration and non-conforming use issue. And according to the court documents, this house is trashed. They originally, when she bought it, it was 175, and the reason why they sold it for $100,000 per documented in the court records is because they considered the house a $75,000 liability. That's straight out of the doc records. The reason why they considered that house such a liability is because of the issue of the deteriorating structure, and
That was a rough estimate, I think, of the demolition cost.
yeah, I don't know how they came up with that.
Estimate.
Yeah, because, and that's my other concern is when I saw those court documents, because I just got a hold of those in the last couple days, 2 days ago. And that was my other concern is, does it references in there the law firm and the lawyer that was the lawyer for the state representative, who was also a lawyer, that they had spent.
There were two different ones. There were, the original personal representative had a firm that she worked with, and then the replacement one had a different firm.
But she also had a lawyer
Yes.
I'm not going to mention any names because I don't want
Okay.
names on the record, but she also had a lawyer for herself because of the situation of the property and how legally complicated it got. And all of the individuals that were living in the property and all the legal stuff and all of the police
Okay.
stuff that was in the mix. And so he was the one that was doing all the footwork with her down in the county. And so you saw the bills, it was like
I
30.
did.
Yeah.
I did, and it looked like a very difficult situation with the personal representative and the issues there, and then the replacement personal representative, the successor. And I think you had a number of interactions directly with particularly the successor.
So one of the things that brought up for me was that the lawyer was talking to the county and the engineering department, or all the different people down there extensively, where they came up with this conclusion because the state really needed money badly. It was really in a dire shape and they had a lot of bills to pay. And I knew Bridget because she was asking me to kind of tell her what was going on because she was in charge of the house and she didn't like going there. And I could see everything. So, but my concern is that it's in that document that they're concerned about being able to do any demolition on the house because they considered it trash and the structurally unsound. Because it sits on a slope that was unengineered fill on the top of the slope with trees that have been identified by PGE, because I just worked with PGE to put a pole on my property with the easement and take the wires off the trees. And the reason why they didn't do it there was because of the safety issues. The reference in the probate records about the questioning on whether they would be able to do the demo, because I was going to demo the house, whether they could do it.
Sure.
And had
I do want to pull this back to the issues here.
that's
And
what
I want to make sure that you have your opportunity here to really direct comments
I
or
can do it
testimony
next
to the non-conforming use issue here.
Yeah, that's what I'm
And yeah,
I know
because I'm
it's-
going to wrap this up in a little bit, and
Okay.
I want to make sure you had your chance.
I really appreciate it. The problem with this house is it's very complicated, so I'm doing my very best.
Sure.
So-
And why don't I am going to keep the record open, and may I suggest that you create a written narrative? Sometimes it's easier for people to do it that way, and I will consider it.
Okay,
And that will give you an opportunity to organize your thoughts. And I know that there are many other issues here because I read through everything you submitted.
well, I've got it down. I can say it in 3 more minutes. I promise.
Okay, 3 minutes.
Yeah.
All right.
So the bottom line is under 1206. It's just strictly that. And this house is way beyond a roof. What do they call it? A roof replacement. This house is trashed and this should be reclassified under a major building permit. It's in the wrong classification, first of all. When the page of the application where you apply for a restoration or rebuilding, and then you have to say why you're doing that, that whole page in the application was blank and instead was applied for through non-conforming use and alteration. And my issue is that they're talking about a 2,300 square foot structure with a roof that's 5 feet taller and you not having a driveway, or they were granted by the county a revocable encroachment permit, which is not a substitute for a legal easement. And the house encroaches on the property that's in front of it, which is on a steep slope. And then above it, the only access that is big enough for all the vehicles that come up and down the road to turn around is what they would need for staging and in and out. My issue is that house is twice the size or 1,000 square feet bigger, which is what's made it a problem through the 20 years almost that I've lived there, is that it's too big of a house for that lot. And I know that's not under what you're talking about, so I'm going to skip it, but it's a major remodel. It's not, it should be under the other DZO, I think it's 1.1206 or something like that. But anyway, okay, so I know that time is short, But since you read that whole legal document, I also am taking issue with the non-conforming use discontinued, because according to Oregon law, it has to be ZDO 1006.02 requires safe, adequate, and lawful access for development approval, and the non-conforming use was discontinued with lawful, with 24 months of discontinued lawful residential use in violation of Clackamas County Zone and Development Ordinance 1206.03.
Okay, I'll consider that.
Yeah, without clear verifiable evidence existing before 1967 and continuous lawful use thereafter, the application fails to meet the criteria of ZDO 1206.02A and 1206.03. And then I was also talking to Maya about the taxes, because they didn't pay the taxes. And I was only showing the deed to show that the house, the first known existence of the property outside of the plat that was sold, was transferred from the owners who developed the plat to the people that actually bought the property, and that happened in 1937. So ZDO 1206.02 places the burden on the applicant to prove that a non-conforming use was lawfully established. Failure to prove the non-conforming use for prior to 1967, the structure was uninhabitable, unsafe, and was a liability. Now, I've only lived there almost 20 years, but it's always been in not like a shack-like condition. Their low-bearing walls were removed in the main part of the house. It always sloped. It was always habitable. I mean, people lived there, and it actually, was nice on the inside with sheetrock and stuff, but it was not trashed, and it had not become uninhabitable. And according to everything it's now considered a hazardous structure. When they sold the property, they had to sign a waiver of liability to enter the property, and it was sold as is with no inspections. And that violates I had a script all written out, but it violates one of the ZDOs and the law. ORS 92.014 prohibits county approval of development without lawful access. Again, the encroachment permit is not a substitute. ZDO 1206.03, it's lost after 24 months of discontinued lawful use. The 1206 allows the applicant to bypass a full building and site plan review, requiring DEQ compliance. Nobody's talking about an oil tank under the house that would have to be removed. He used crank oil in that. ZDO 703 is a floodplain management. Oh, here it is. CCC 9.10.060 prohibits maintenance or occupancy of unsafe or dangerous buildings. And
I think I do understand, and I did read all the materials that you submitted. And again, I'm going to provide an opportunity for members of the public is also to have a chance to participate today. Please reflect on what you presented here at the hearing, and if there's something new or different that's relevant to the criterion that I'm to base my decision on, please submit that, and I will consider that as well. I'll discuss the timeline for that before I close this hearing. Okay. At this time, I'd like to provide an opportunity for members of the public to provide a comment. use the raise hand feature if you'd like to make a comment for me to consider.
I have Lisa.
Please state your name and your address, your full name, please. You're on mute as well. Is this Lisa Scholmeyer?
Yes.
Okay.
Can you hear me?
Yes.
All right. My address is 40342 Southeast Cedar Creek Lane, Sandy, Oregon, 97055.
Thank you.
So, I am the neighbor. Lori is across from me, and Jennifer and Terry are to the side of me. I don't know any zoning codes or will be reciting them, but what I can tell you is that since they have gotten the house, they have worked on it every weekend, and early when they got it, they cleared everything out of the house. All the old, I mean, the stove was from probably 1930, not really, but so they got all that cleared out. But that's beside the point. We're talking about the roof. We've had the fire truck and an ambulance down here twice within the past 6 months. They had no problem navigating it. I know for sure because one of the times I was in the ambulance. If they want to get a roof on their house, that is going to do nothing but do good for everybody else's house on that street. I've been inside of it last week. There's not a lot inside, but there's a lot of new beams. I see them trying to get permits and do everything the right way. I will not speak on anybody else because I don't want to talk mean about people. But I do think there are issues that lead Miss Ryland to where she is today. But them having a roof is going to do nothing but beautify their house and enrich my house, the property of Miss Ryland's house, and everybody on this street. And that's about it.
How long have you been a neighbor?
Almost 11 years.
Looks like a nice spot by a creek.
It really is. And you know, we are so lucky to be out here. And I just want everybody to get along. And like I said, the more they do on their house, the more my property values go up.
Thank
And
you
I would
for
sure-
your, oh, go ahead.
No. I was just going to start talking again. I am done.
Okay. Thank you for your participation and your citizenship.
Thank you. You have a wonderful rest of the day. And thank you, Your Honor.
Do we have another public participant?
I know that Maggie Russell wanted to testify, but I don't know if she's able to raise her hand.
Let's give it a minute. Not everyone is that familiar with using the Zoom platform.
It's *9 if you're on a cell phone.
If you do want to provide public input, use the raise hand feature. At this time, I'm going to offer the applicant an opportunity for rebuttal. The applicant is not required to provide rebuttal.
Thank you. I will be quick. I think that many of the issues the appellant raises would be addressed by allowing this alteration of the non-conforming use to happen. And I don't think that there's any evidence in the record that demonstrates the house is in the residence is in a state that would have to in order for it to go beyond an alteration to a non-conforming use, but to a replacement of a destroyed non-conforming use. So there might have been squatters, and the squatters might not have treated the house well, but the house itself still exists. And in any event, because we are focusing on a setback encroachment, there's again no evidence in the record that the setback encroachment has been discontinued, and that's the critical piece of this. I think there was a reference. Access is outside of the scope of this. Concerns about health and safety. I think that, as I said initially, when we're focusing on the setback encroachment, there's nothing other than the affirmative evidence in the record described by staff and introduced by the applicant in their set of exhibits exhibit 2, that demonstrates for the past 20 years the setback has been continuous. And so I appreciate your time, and that's all. Thank you.
Thank you. I'm going to make a statement about an open record period. And it's in sort of, yes, Ms. Cabnet.
I'm sorry, but Maggie is contacting me and she hasn't been able to get in. Can she call in?
Yes, the call-in information should be on the most recent email that I sent her.
Okay, I don't know how to do everything all in this moment, but I just wanted to see if I could. Is there still a possibility for that? Or is it as the time passed?
What I would provide is an opportunity for her to submit a written statement. Okay, well, I think we should proceed to finish up. This is a statement that I'm reading concerning the record. Prior to the end or the close of the record, does any party or member of the audience want an opportunity to provide additional evidence, arguments, or testimony? Does the applicant wish to waive the period for final written argument? So I know that the applicant's already requested an open record period to submit additional evidence. Do we have 7 days?
Yes, that's fine.
Okay. So and for the appellant as well. So during this 1 week, 7-day period, any party can submit additional evidence related to the approval criteria. So arguments, evidence, written testimony of that nature to the record, including new evidence that hasn't been introduced today. And our members of the public can also submit a written statement, and I'll consider it. A second, let's get a date on this. That initial 7-day period ends 7 days from now. So 8/21 at 4 p.m. So please submit anything you want me to consider by 4 p.m. on August 21st. A second 7-day period, meaning 8/28 at 4 p.m. for rebuttal. So rebuttal of evidence that was either during the testimony today, exhibits that have been submitted. It can be rebuttal of anything that's submitted during that first 7-day period. Okay. Now, a final 7-day period just for the applicant, a final written statement, a last word, no new evidence. You can submit argument rebutting things that are already in the record, but nothing new. Okay. Do you have any questions about that, Mr. Martin?
I do not. Well, except it's submission by emailing it
I need a
to
date.
Maya.
Yes. What is 7 days from that?
September 4.
Thank you. By September 4th.
Thank you.
Okay, so 9/4 at 4 p.m. Okay, are there any other questions before I close the hearing? No? All right, then the record will stay open as I just described for 7 days for the submission of new evidence, testimony, arguments, written testimony, I mean, by any party. A second 7-day period for rebuttal and a third 7-day period for a last word. For the applicant only. Now the applicant can waive that period by submitting a email to Ms. Renhard or to Ms. Ganser requesting that the record be closed in that 3rd-week period. Okay? All right, I think that wraps it up. Well, thank you all for your participation today. And with that, I'll close the hearing.
Thank you.
Thank you. It was a pleasure meeting all of you.
Thank you.